HR Simple publishes state-specific human resources manuals, and we work with employment law attorneys all across the country to do that. Our speaker today is our Texas Human Resources Manual author. So I'm going to put a link in chat where you can access those books for those of you who aren't members yet. We'll be offering a 20% discount code in the chat as well. That'll be good for end of the day tomorrow. That code expires. So if you have any questions or need more info, just contact me. I will also put my contact information there. All right, so we have all that stuff out of the way. I want to introduce today's speaker. I reached out to CB originally because one of her colleagues covered this topic for us a few years back. And to this day, it's still one of our most popular webinars on our YouTube channel. I think it's got over like 25,000 views. And so we thought it might be time to revisit the topic. So, as I mentioned, CB is the author of HR Simple's Texas Human Resources Manual. She's joining us from El Paso, Texas, where she is a partner in Kemp Smith's Labor and Employment Law Department and a member of the firm's management committee. CB represents employers in all aspects of workplace law, including advice and counseling, workplace investigations, handbook and policy reviews, and litigation defense of discrimination, discharge, and other employment matters in the federal and state courts of Texas and New Mexico. CB is ranked in the top tier of labor and employment lawyers in Texas by Chambers USA, recognized as a Texas super lawyer, and listed in Best Lawyers in America. That's a lot of recognition. So we're so happy to have you here, CB. Thank you so much for joining us.
Well, thank you for having me, and let's just dive right into it. We're going to talk about the EEOC retaliation guidance and how we make employment decisions in light of that guidance. So let's start first just to talk about kind of the difference between discrimination and retaliation, where our focus will be mainly on retaliation. But we all know we have federal laws and state laws that prohibit discrimination and retaliation. So when we talk about discrimination under federal and state laws, we're talking about decisions. Employers are prohibited from making decisions when the basis of those decisions are someone's membership or status in a protected classification, such as their race or their color or their age or their gender, whether they have a disability, what their religion might be, genetic information, their gender orientation. So all of those are protected statuses or classifications, and employers cannot discriminate against someone based on those. Retaliation is more, I should say, specific, because it prohibits employers from taking adverse employment actions against employees because they engaged in protected activity. And as we'll talk about later on, the protected activity may not actually be actionable discrimination, but it still may be a complaint about discrimination. But what we're looking at here is an employee opposes an unlawful employment act or practice in some way, and an employer takes adverse action against them because of that. So an employer is punishing that employee for exercising their rights under, whether it's Title VII, the Age Discrimination and Employment Act, ADA, Equal Pay Act, GINA, or your state laws, state statutes that prohibit these same forms of discrimination. So that's kind of the difference between discrimination and retaliation. And then, as I said, we're going to focus on retaliation today. And specifically, we're going to focus on the EEOC's guidance, which was actually issued back in 2016. But we sort of, we've kind of gotten lost in the pandemic for the last few years. And so that seems like a long time ago, but it's, or it may not seem like a long time ago. But so that guidance superseded a 1998 version of guidance. The guidance was originally released in January of 2016 for public comment. That occurred, and then the EEOC issued its final guidance on August 29th. of 2016. And what that guidance does, it explains how the EEOC investigates charges, makes cause determination, and views litigation. It contains a very broad construction of anti-retaliation laws. So the objective of it is, from the EEOC's perspective, to make it easier to find retaliation, which in turn leads to more lawsuits. As it is, retaliation has steadily, the number of charges have steadily increased, particularly in proportion to the other types of claims that can be made to the EEOC. And so just in 2022 alone, the numbers are indicating that over 50% of charges or lawsuits filed involved some sort of retaliation claim, maybe on its own or in combination with other types of discrimination claims. So you can imagine retaliation claims, we're seeing more and more of them, basically. And so we have to be very careful about them and take them seriously and try to avoid them. So what are the elements of a retaliation claim? Well, the employee has to engage in protected activity. The employer, in response to that protected activity, takes adverse employment action. And when I say in response, that's this next step. There has to be a causal connection between that protected activity and the adverse employment action. So those are the three elements, and they're not new, but we see in this guidance, the EEOC interprets them very broadly. So again, employee engages in protected activity, employer takes an adverse employment action against employee, and the employee establishes that there's a causal connection between those two events. So what is protected activity? Obviously, it must occur before the adverse employment action is imposed. I mean, if somebody's terminated and then they go complain, then there's clearly not a connection there. So they do not engage in protected activity before the employment action. Protected activity, it's important that the decision maker know about it. Because if the decision maker does not know that an employee, for example, filed a charge of discrimination or reported something internally, then that couldn't have factored into the decision maker's decision. And then it's established by showing that the employee either participated in an EEO activity or opposed discrimination. And those are really two critical components. Either one of them is sufficient. So an employee can participate or oppose. So let's talk about those in a little bit more detail. So what does it mean to participate in protected activity? It means filing a charge, testifying, assisting, or participating in any manner in an investigation, proceeding, hearing, or litigation under the law. So if someone goes and files a charge of discrimination with the EEOC or with your state EEO agency, that's participating. That's protected activity. It's broad protection, even if the underlying claim, and I mentioned this earlier, even if the underlying claim of discrimination is meritless or untimely, the protection still applies. So someone can have a valid retaliation claim even if their underlying report of discrimination or claim of discrimination has no merit, or even if that was untimely. And by that, I mean most Title VII and other federal laws require charges of discrimination to be filed within a certain time period. Generally, and it depends on what state you're in, it's either 180 days or 300 days. Let's say someone doesn't file that charge within 300 days, and so they filed it untimely, but the fact that they filed it is protected activity, so they cannot be retaliated against for filing it. So an employer couldn't get off the hook by just claiming that the charge was untimely. And the point of this, according to the EEOC, is we want to avoid having a chilling effect. We want to avoid discouraging employees from reporting or claiming or doing things to assert their rights under the law. So there's no reasonableness test here is kind of the basic notion there. The EEOC also construes participation clause to apply to internal complaints. So it's not just going to the EEOC to file a charge of discrimination. It can be a complaint that is made internally. construing, complaining to HR, for example, or complaining to an employee's supervisor or manager that they believe they're the victim of discrimination, or that a coworker is the victim of discrimination. And we'll talk about things like that in a little bit more detail. So the EEOC wants to encourage internal complaints without fear of retaliation, regardless of the merits of that complaint. It's also not limited to EEOC investigations. A participation in a company investigation is protected. So if a witness is giving a statement in connection with an investigation conducted by a company of an internal complaint of discrimination, that witness is engaging in or is protected by the participation clause that we're talking about. All right, let's talk a little bit more about some issues with participation clause. Employees who invoke the participation clause are not immunized from otherwise appropriate adverse employment actions. So this is important, particularly from an HR perspective, because we're always worried about, well, just a minute, this is a employee with lots of issues, but they've complained about discrimination. Does that mean that I can't continue to address the issues or their performance problems or their disciplinary problems? So that's what we're talking about here, is just because somebody has participated does not mean that they cannot otherwise be subject to appropriate disciplinary action. So employees can still be disciplined for legitimate, non-retaliatory reasons, even if they have engaged in protected activity. Now, again, this is a little bit watered down because this guidance really broadens the standard for proving retaliation, but the EEOC gives us a couple of examples of what it's talking about with respect to employees who invoke the participation clause not being otherwise immunized from being disciplined. So example one is a saleswoman who has excellent performance. She gets good reviews, and she is terminated after providing a witness statement to the EEOC in support of a coworker's harassment claim. And the reason that was given to her for her termination is that she failed to provide 48 hours advance notice in order to swap a shift with someone. And the evidence in the particular case was because same day, or at least according to EEOC, their view of it is because the same day notice requirement was commonplace. So people were giving it on the same day, not just 48 hours in advance. And then there was a close proximity between the time of the witness statement and the termination. The EEOC finds cause in that particular charge. Contrast that with example two, where a female employee believes she was not promoted because of her gender. And so she posts on her Facebook account, "Anyone know a good EEO lawyer?" The employer saw this and fired her shortly thereafter. However, there's no cause because the evidence showed that she was fired for taking unauthorized overtime. So, and in that particular case, you would look at, have we fired other people for taking unauthorized overtime? Do we make it clear that you have to have authorization before you work overtime or submit overtime? And so in that case, the EEOC said, that evidence was substantial in comparison just to her post, "Anyone know a good EEOC lawyer?" All right, so let's talk about the other part, the other way that you're protected or that an employee is protected. So we talked about the participation clause. Now we're going to talk about the opposition clause. And the opposition clause protects individuals who oppose any unlawful employment practice. So it applies if an employee explicitly or expressly or implicitly communicates a belief that discrimination may be taking place. There's no magic words here. There's no legal terminology. An employee does not have to use the word harassment or discrimination, but it must be enough to give the employer reasonable notice. And if a complaint can be reasonably interpreted as opposition to discrimination, then the complaint is protected. Again, the guidance expands the reach of the opposition clause, just like it does the participation clause. So here are some things, here are some ways or that qualify under the opposition clause. accompanying a coworker to HR to file an internal EEO complaint. So the employee may not actually be participating or filing, but accompanies a coworker and therefore is considered to be opposing discrimination. Complaints about discrimination directed not at the employee, but at coworkers. So again, that's a case where the employee is opposing discrimination, not complaining about discrimination against her or himself, but discrimination that's against coworkers. Refusal to fire. This would be a supervisor or manager, for example. Refusal to fire an employee if they believe the reason is discriminatory. So they may be told by a manager, I want you to go fire this employee, and this person who's being directed to fire the employee believes that instruction or direction is based on a discriminatory reason. They believe this manager, is trying to fire this employee because she's female or because he's over 40, whatever the underlying reason is. If that employee that's being directed to refuses to do it based on that belief, then they are opposing discrimination and they're protected. Okay. Now here's good news, because there's a lot of interesting law on this particular issue, but good news for everyone. Managers and HR personnel can be protected for opposing discrimination as well, even if that's part of their jobs, because many managers in HR have responsibility that if somebody is coming to them and complaining about discrimination, then they have an obligation to investigate it, take prompt remedial action, or maybe they're not specifically in charge of doing that, but they need to report it up the chain of command. So that's part of their job. And there's some cases across the nation, not a whole bunch, but some, and they're fairly old. There's not any really recent ones, but would say, well, a manager and HR person who's terminated after they've done something they're supposed to do can't show that they're opposing discrimination because it's part of their job. Well, the EEOC rejects that in their guidance and says it's rejection of the so-called manager rules. It says required managers to step outside of their management role and assume a position adverse to employer in order to engage in protected activity. So the court says that's no longer, or the EEOC takes the position that that's not the rule. It's not simply requiring managers to step outside their role, but even if they are acting within their role and they are opposing or reporting discrimination, then they can be protected. So it provides protection to those best suited to stop discrimination in an organization. All right, more on the opposition clause. Complaints to someone other than an employer can be protected. So doesn't have to be directly to the employer, but it might be a union official, maybe a coworker, maybe an attorney, could be a law enforcement authority. For example, if an employee, instead of reporting something internally, goes to the police to report a sexual assault against a coworker, and that information comes back to the employer, that's protected activity. So that they're opposing discrimination there. Even merely advising the employer of an intent to complain or file a charge, not following through, that's still enough to constitute opposing discrimination. EEOC says that a reasonable opposition includes informing employer about potential discrimination or harassment, even if it has not risen to the level of severity or pervasiveness required. And that's important because if you think about it, we all know, let's say that somebody has told one joke, and that's all. If a person that's the subject of that one joke would not, they probably could not prove a sexual harassment case or a hostile work environment case, because the elements of that particular discrimination is it's got to be severe or pervasive. And if it's a one joke situation, the joke's not severe and it's not pervasive because it was one time. So that person would not succeed on sexual harassment, hostile work environment theory. But let's say that person still complains, then they have engaged in protected activity. Regardless of whether the underlying conduct would meet the elements for hostile work environment, they're still reporting something they believe to be harassment. And that is opposing discrimination. That's opposing. So they're protected at that point from retaliation. So remember that just because the underlying discrimination complaint may not have merit or may not be sufficient, the fact that they're reporting it can be participation or opposition, as we've seen. So what does the EEOC consider to be unreasonable opposition that would not warrant protection? In other words, I mean, what doesn't meet it? Well, complaints not involving discrimination or harassment. Yeah, duh, as we say. Complaints about work performance, for example, if an employee is just complaining about somebody else's work performance, or they're complaining that they're not being evaluated, that they disagree with the evaluation, but they don't tie it in any way to some type of protected class, or they don't tie it to protected harassment, then that's not a complaint that would be considered reasonable opposition, and it would not be protected. How about badgering a subordinate, for example? Badgering a subordinate to provide a witness statement in support of a claim, or coercing an employee to change a statement. So that's not protected activity. Obviously, committing or threatening violence to life or property is not protected activity, but pretty much everything else, according to the EEOC, is fair game. So important to remember that. Opposition must be based on a reasonable good faith belief that the conduct complained of violates the law, even if the conduct is not unlawful. So again, complaining of harassment that is not severe or pervasive. An employee may reasonably believe that's still unlawful harassment. We talked about that a moment ago. That can still be opposition, even if the underlying claim is not going to meet the elements of sexual harassment. Again, the EEOC's goal is to encourage people to complain, even if they're wrong. And as a result, employers really have to think about it and understand. And EEOC's position again, too, it's even in the employer's best interest for an employee to complain early about harassment, because then the employer has time to do something about it before it reaches the point of creating a hostile work environment. So that's why even complaints about conduct that may not rise to the level of severe or pervasive, if still that's a good faith complaint, and the employer is encouraged to address it, do something about it, and obviously not retaliate against the employee. So here's an example of good faith belief. Employee complains of sex discrimination after not being promoted and a less qualified male was selected. I mean, we would all understand that. If an employee complains about that and can establish that somebody who is less qualified and not a member of her protected class was selected, that would be a good faith complaint. Here's an example of one that's not motivated by good faith. Let's see, the job required a CPA license, and that's posted. A female employee applies for that job, but she doesn't have a CPA license, and a male individual with a CPA license was selected. So if she complains about discrimination, the EEOC even says that's not a good faith complaint. That's not based on a good faith belief, because the job required an accounting license or a CPA license, and she didn't have it. So it wasn't reasonable for her to believe that she was the victim of sex discrimination in that particular case. Some other examples of protected opposition: complaints based on a legal position taken by the EEOC, even if not adopted by the courts. And the example given in the guidance, which is now a little bit outdated, is complaining about sexual orientation discrimination, even though in 2016 it was not protected, or was not recognized universally as being protected under Title VII. Now, the Bostock decision from a couple of years ago changes that. So we now know that sexual orientation discrimination is considered to be unlawful sex discrimination. But there may be other positions taken by the EEOC that are rejected by the courts, and the EEOC's position is those still are, if somebody's complaining about that, it's still protected opposition. There's some complaints that the EEOC says are just going to be, we're just going to look at them and know that they're a complaint about discrimination. And this next example is one of those: complaining about graffiti in the restroom that is derogatory to women. Well, even if they don't say, hey, I think this is sex discrimination, but they're complaining about graffiti that clearly is sexist in nature, the EEOC's, that's a reason, it can be reasonably interpreted as a complaint of sex discrimination. So we consider that to be protected opposition. About a witness who corroborates information about harassment she witnessed or experienced. Even if she didn't complain, that's protected opposition. So if she's interviewed in the course of an investigation and she corroborates something that's being said, then that, whoops, got to hit that. Anyway, she's protected. That's considered protected opposition. An employee who intervenes on behalf of a coworker, asking the harasser to stop. So, employee in that situation, what that we're talking about there is somebody is witnessing what they believe to be harassment, and they intervene on behalf of their coworker. Well, that's protected activity. Here's an interesting one: religious or disability-based requests for reasonable accommodation. Those are protected activity under the ADA and under Title VII. Now, various state statutes may not consider that to be protected activity. For example, in Texas, it's not automatically considered protected activity to request a reasonable accommodation. But the way the EEOC has interpreted Title VII and the ADA is that those requests in and of themselves are protected activity. So you need to keep that in mind, that once you receive a request for a reasonable accommodation, the person is now protected from retaliation. And the EEOC also says protected opposition can occur even if the protected activity involved a different employer. So if during the course of employment, an employer learns that this employee had filed an EEOC charge against a prior employer, or had testified in a lawsuit that involved discrimination or sexual harassment, for example, involving a prior employer, well, that's protected activity, and this new employer cannot act against the employee based on that protected activity that involved that different employer. So again, it's very, very broad. Okay, so we've talked about what is the protected activity. Now we're going to move to what is an adverse employment action, according to the EEOC. And it's any action, and this definition comes out of a Supreme Court decision, but the EEOC has obviously followed it and adopted it. So it's any action that is materially adverse, meaning that it would dissuade a reasonable person from engaging in protected activity. So again, any action that is materially adverse, which means it would dissuade a reasonable person from engaging in a protected activity. It's very broadly interpreted by the EEOC. It includes obviously ultimate employment decisions or actions, which we certainly understand. Somebody who's not hired because of protected activity, somebody who's fired, demoted, has a pay reduction, maybe is, gets a poor evaluation, anything that is something you can put your hands on, that's tangible. We know that happened. It does not include, and this is longstanding law, minor annoyances, petty slights, trivial matters. But that's sometimes hard to figure out whether something's just a minor annoyance or a petty slight or trivial. So context matters. What might not be adverse to one employee might be adverse to another employee. And it's just like we hear somebody has made a complaint and suddenly their supervisor refuses to talk to them, doesn't talk to them anymore. Or they made a complaint about a coworker, and then that coworker, gives them an evil stare every time they walk by. Well, are those minor annoyances? Are those petty slights? Are those trivial? Hard to say, because context matters. So we need to know all the circumstances there. But certainly if that person complains and then they are at some point thereafter fired or demoted, then they're going to be able to establish that adverse employment action. All right. Some more adverse employment actions that the EEOC identifies in this guidance. Work-related actions, it said denial of a promotion, a suspension, discipline, negative evaluations, transfers to less prestigious positions, or maybe to a less prestigious work area, being excluded from work meetings that are necessary for advancement, being left out of things, basically, Almost anything that could impact the employee's standing in the company is going to satisfy that adverse employment action definition. It can also include non-work related actions, actions that cause employee harm outside the workplace. Altering schedule, for example, to interfere with a single mother's ability to pick up a child from school. Filing a false report with the government authorities, defaming a person outside the workplace. Giving an inaccurate or false job reference to a potential employer. Threatening deportation or revoking a visa to initiate action with immigration authorities. Scrutinizing performance. So even non-work related actions, and the easiest one to grasp is giving a bad reference to somebody who has left your company after making a complaint or engaging in protected activity. Are they going to link that protected activity to that bad reference? Possibly, and you've got a retaliation claim on your hands. So you've got to understand that. And some of these that I just read, these non-work related action, courts have said, no, those are not adverse employment actions. Well, the EEOC says, we don't care what the courts say, we think they are. So they say, as the EEOC says in this guidance, we believe the courts are wrong when in some of these cases where they found an adverse employment action or not found an adverse employment action. All right, more on adverse employment action. If an employer's action if it's reasonably likely to deter engaging in a protected activity, it can be challenged as retaliation regardless of the harm. What does that mean? An employee doesn't even have to show that they have suffered something, that they've got a demotion or whatever. The point here is if an employer has done something that would deter an employee from engaging in protected activity, then it can be challenged as retaliation. So it's no defense that the employer's goal of deterring protected activity actually fell short. And we see this argued a lot in cases. An employer will say, well, yeah, obviously we didn't take adverse employment action, or what we did was not adverse employment action because the employee went ahead and filed a charge. Well, the EEOC says that's not a defense. The fact that the employer actually filed a charge or engaged in protected activity doesn't mean that the employer can say, well, we didn't engage in or our action didn't deter the protected activity because it in fact happened. EEOC doesn't buy that defense. So basically anything that could be viewed as negatively affecting an employee, even in a minor way, will be considered an adverse employment action according to the EEOC, even if it has very little or no tangible effect on the terms and conditions of employment. So again, it's a very broad definition. And the EEOC's, their mindset is we want these claims to be, we want retaliation claims to be made. We want them to survive. We'll investigate them when they're brought in charges, and we want them to survive in courts, even if in the past they would not have done so. Okay. The retaliation guidance also discusses third-party retaliation. So when an employer, what do we mean here? When an employer takes a material adverse employment action against an employee who engaged in protected activity by harming a third party who is closely associated with the complaining employee. So we're talking about like a family member here. And they give some examples. A company employs a husband and wife. The wife complains about unlawful discrimination, and the company turns around and fires the husband. So would the husband have a claim? Because he didn't engage in protected activity. But the EEOC says because of his close association with the wife, it's his wife who did complain, that he is protected, even though he did not specifically engage in protected activity. Same thing, company punishes a complaining employee by canceling a vendor contract with the employee's wife's business. So that employee can say, hey, we've been affected because the company retaliated against my complaint by canceling my wife's business contract. A victim of third-party retaliation can sue too. So just what I said, victim, not only the employee can sue, but the person, the husband, the spouse, whatever, can sue for retaliation, even though they never engaged in protected activity. Because what the EEOC looks at is there's a zone of interest. So the family member is in that zone of interest, and the employer has been able to retaliate against the employee by targeting that employee's family member. So something that's important. We need to understand and avoid those types of retaliation. Okay, so we've talked about the protected activity, which can either be participating or opposing. We've talked about what constitutes an adverse employment action. Well, we now are going to talk about causal connection. So what connects those two things? What connects the protected activity to the adverse employment action so that an employee would be able to move forward or recover on a retaliation claim? So, because an adverse employment action is not unlawful unless it's taken because the employee engaged in protected activity. And this is really where, as HR professionals, where the meat of what you do is, because you have to manage people who may have disciplinary problems, but they've also have a history, or they did engage in protected activities. So how do you manage that? And so that's what this causal connection is all about. The employee has to prove that causal connection. So it is their burden to prove that there's a connection between those two events in order to sustain their retaliation claim. And when an employer provides a lawful reason for the action, the employee has to discredit the employer's reason. And this deals with the burden of proof in an employment case. But essentially, if the employee establishes, hey, I suffered an adverse employment action, I engaged in protected activity, then the employer is going to have to say, okay, well, they're going to have to put on evidence of why they did what they did. Why did they take the adverse employment action? And then this burden shifts back to the employee, and they have to show, hey, they're lying about it, or here's the real evidence. So they've got to discredit whatever the reason is given by the employer. One way that an employer can prevail, though, is they can show, hey, the decision maker did not know about the protected activity. So if the decision maker did not know about it, then the employee cannot prove retaliation. But I do want to say there's a little thing, and the EEOC guidance doesn't discuss this in any great detail, but there's case law that says even if the decision maker did not know about it, but if they were influenced by someone who did know about it, then it's a theory called the cat's paw theory. It's basically the cat's reaching out and getting the decision maker to make a decision that's unlawful. So employees can still, there is still an avenue an employee can recover, even if the decision maker did not know about the protected activity, if the employee can show that someone else was influencing that decision maker. So maybe the decision maker, maybe a high level manager, doesn't know about it, but the supervisor's coming to that manager and saying, we really need to get rid of this employee. He's a bad apple, or she's a bad apple. And so the manager looks at it and makes that decision. Well, it comes to find out, or it's established later on, that supervisor has been the subject of a discrimination claim by that employee. So the decision maker didn't know that. Maybe it was handled internally, but that's the cat's paw. That supervisor is influencing that decision maker. But short of that, if the decision maker did not know about the protected activity, then the employee is not going to be able to establish retaliation. Okay. How do you establish the causal connection? Well, the standard articulated in this EEOC guidance is there's a convincing mosaic of circumstantial evidence that would support an inference of retaliation. Means that employee can rely on bits and pieces of evidence. It doesn't have to be all consistent, doesn't all have to be linked. It can be bits and pieces of evidence, which when combined together show a retaliatory intent. So what can these types of evidence be? Suspicious timing, close proximity in time. It's very easy for courts to infer retaliation if the adverse employment action was taken in close proximity to the protected activity. So if the employee complains about sex harassment and then 2 weeks later is terminated or maybe laid off and a reduction in force, well, there's a close proximity there. And so court may be more willing to infer retaliation course, the burden's going to shift to the employer to show, hey, we laid off everybody, or we laid off everyone in that department. So we can disprove any connection. But remember, the closer in time that the adverse employment action is to the protected conduct, the more difficult it is for the employer to survive those types of claims. The EEOC, now what is close proximity in time? The EEOC has found that it can be as long as 14 months. When, in that particular case, an employer kept mentioning the protected activity. There's one example cited by the EEOC that found retaliation by an employee who had filed an ADEA lawsuit 5 years earlier. But again, there was evidence that showed that the employer didn't just forget about it, that it kept coming up. But there are lots of cases, though, and particularly, I'm in Texas, and we've got the Fifth Circuit, which is generally pretty conservative on employment litigation. There's lots of cases that say, 3 to 6 months is not close proximity. Certainly a year would not be close proximity. So if you've got those longer time periods, generally there's going to have to be more evidence than just the time period to connect the dots. How about what are some other types of evidence that can establish a causal connection? Verbal or written statements by decision makers that may show inconsistencies in the reason given for the action. We see this come up a lot where the employer may put on, the termination notice. They'll say the employee, performance-based termination. But then when they respond to an unemployment claim, it says employee falsified documents. So they're giving inconsistent reasons for taking the action that they took. And maybe they're the same thing in the employer's mind, but they didn't characterize them the same way consistently. So when you have those types of inconsistencies, you got to be very careful, because you want to make sure your documentation is consistent so that you don't have that coming back to say, or an employee coming back with that evidence to say, well, obviously the employer is not telling the truth here because they're giving different reasons for my termination. So that type of evidence, courts will say, establishes a causal connection. Comparative evidence showing that similarly situated employees who did not engage in protected activity were treated better. So if you have somebody who complained about discrimination and was terminated for like a 3-day no call, no show rule, but that employee can show there were other employees who were not terminated for 3-day no call, no show, and they didn't engage in reporting discrimination or protected activity, then that raises a fact question of why was the person who complained treated differently? Evidence that the employee had a higher performance rating, and then after engaging in the protected activity suddenly was deemed to be a low performer or a poor performer, or somehow that employment evaluation went down. Also, inconsistent or shifting explanation in an employer's reasoning. So what is the reason the employer has given? Has that shifted over time? If there's inconsistencies there, that can be problematic. Not following employer's policies, that can be evidence of causal connection. So if an employer's policy says, employee has so many or has 3 or progressive discipline, for example, they should get a written warning, a final written warning before termination. If an employer deviates from that with respect to somebody who's taken protected activity, that's going to be problematic. So we want to watch out for those things. So what does the EEOC say you should do to minimize retaliation? Okay, one, have an anti-retaliation policy. We all have EEO policies in general, but we should also specifically address not retaliating and provide specific examples in those policies that employees and managers may not have otherwise realized that could be construed as retaliation. And some of those are what the examples that the EEOC gives in this guidance. Provide steps in your policies for dealing with or minimizing interactions by managers and supervisors with employees who have asserted claims. And, we see that obviously in sexual harassment claims. We want to separate the person who's complaining and maybe the person against whom they're complaining so that they don't have a lot of interaction. You want to be careful about it, though. Don't minimize it or don't do it in such a way that's detrimental to the person complaining. So be cautious about that. Describe the avenues for reporting retaliation in your policies, just like, hey, employees are required or supposed to report discrimination. They should also be encouraged to report retaliation. And then state that employees who engage in retaliation will be subject to discipline up to and including termination, just like you would people who violate other policies. The EEOC also suggests training, provide regular training to all employees on the written anti-retaliation policy. And then they also say provide anti-retaliation and advice and support to employees, managers, supervisors during and after an EEO investigation. So when you're meeting with witnesses and you're investigating a complaint, provide them the anti-retaliation policy so they understand how it works. Provide advice and support to persons accused of discrimination so that they understand they need to be very careful about their actions so that they're not perceived as being or perceived as retaliating against the employee who has complained. Provide guidance on how to handle personal feelings when carrying out management duties. You know, managers need to take the emotion out of it and, you know, not have their feelings hurt and not act on those hurt feelings because somebody's complained about them. So they need to behave in a professional manner, and the EEOC is encouraging training on that. And remind employees not to disclose or discuss an employee's pending EEO issue or complaint, which is, you know, sometimes inconsistent with what the NLRB tells us about confidentiality. But the EEOC's position is that you should respect confidentiality and remind employees not to be discussing the complaint while the investigation is ongoing. Then they also encourage proactive follow-up with employees both during and after an investigation. You know, make sure they're not experiencing any perceived retaliation. And if they are, then, you know, look into it. And then review consequential employment actions to ensure EEO compliance. So particularly as HR professionals, if you know that there's been a complaint, a protected activity, and now you're being asked to bless a termination of that employee, you want to be very circumspect about that. Make sure all the I's are dotted and the T's are crossed and that the action can be defended. Make sure that the evidence supports that decision. All right, with that, I think we have a few minutes left and we will switch over to any questions that we might have.
Awesome. They really don't make it easy on HR professionals.
I can't hear you, Amy.
Oh, you can't hear me? Can you turn your volume up? Hang on one second. Can everyone else hear me? Okay. Let's see.
Still not hearing you. They can hear you. I can't for whatever reason. I don't know why. I guess everybody can still hear me.
Yeah, okay. I can hear you.
I know there were a couple of questions. Let me see if I can remember what they were. Just hang on 1 minute.
Here. All right, I'm just going to.
There was a question about how to deal with difficult employees, particularly once they have made a complaint of discrimination. And yes, that's $1 million question, and that's probably the most difficult thing you have to do as a HR professional, and particularly guiding supervisors and managers on that. The bottom line is, as we saw in that EEOC guidance, is that you still have the right to discipline and take appropriate employment actions, even against people who have engaged in protected conduct. So you want to follow your policies, make sure your policies are being followed, that you're being consistent in treating that employee with the way you would others. but certainly don't give them a pass. I mean, if they're engaging in if they're engaging in problematic conduct, you need to address it. You just need to be aware that, you know, their response may be, well, this is retaliatory. You just need to make sure that you're following your policies and you're addressing it as appropriate. So another question, after giving a complaint against a supervisor, would harassment be considered retaliation? And I guess this is somebody has made a complaint about their supervisor and they're saying that after that they're being harassed. Yes, because harassment would be considered an adverse employment action by the EEOC. So anything that affects that employee, basically affects that employee in an adverse way, would be considered an adverse employment action under the EEOC's expanded definition. So that is definitely harassment would fall into that category. So you definitely want to be understand and address that as appropriate. Is there any more? I don't think so.
Let me check real quick. Okay.
I don't see any more. I can't hear you, Amy. I'm sorry. I don't know what the issue is, but
that's okay.
I'll let you finish up.
Okay. All right, that wraps up all the questions. So again, I will send everybody the credit codes and the recording. Oh, looks like we have one more that came in.
Okay, I can hear it now. So.
Oh, cool. Okay.
Do you for whatever reason it came on?
That's weird.
Yeah.
Okay, good. Do you see the last question that just came in?
Yes. Okay. So we just finished the EEOC lawsuit. Young lady changed her title without permission and then quit for other employment, filed a claim that we discriminated against her in pay, that she did not get paid the same wage of the male counterpart who had been 20 years and more experience than her, and she lost. We don't understand why the EEOC sided with that young lady. Yeah, that's hard to understand just based on that description. She changed her title without her permission and then quit. She claims she was discriminated against in her pay. And I guess, I mean, that must have been the basis for the decision, was they looked at this as an equal pay case and decided that she had the same experience, qualifications, whatever, as her male counterpart, but she's paid less. So it looks like they just viewed it as an equal pay situation or an unlawful discriminatory pay situation based on, you know, what I'm reading. So presumably that's why they found the way they found.
Okay. Awesome. All right. Well, that wraps it up. Thank you, everybody, for joining us today. You'll get the emails tomorrow. And thank you so much, CB, for coming and sharing your expertise and time with us. We really appreciate it. This stuff is really complicated and difficult, especially I know for small businesses with not a huge HR department. So we really appreciate your time. Thank you so much.
Thank you.
All right,
Bye.
everyone, have a great day. Bye-bye.